right, this is the 120 class. This is going to be some 120 warm-up for the record. A fundamental principle of our system of criminal law is that the defendant is presumed to be innocent. The mere fact that he was arrested and was charged with these crimes is not evidence of his guilt. Furthermore, the defendant is presumed to remain innocent throughout the trial, and unless and until you conclude, based upon careful and impartial consideration of the evidence, that the Commonwealth has proven the defendant guilty beyond a reasonable doubt of these charges made against him. It is not the defendant's burden to prove that he is not guilty, nor to prove anything in his own defense. Instead, it is the Commonwealth that has the burden of proving each and every element of the crimes charged, and that the defendant is guilty of those crimes charged beyond a reasonable doubt. And I will give you the elements for the crimes charged here in just a moment. If the evidence presented fails to meet the Commonwealth's burden, then your verdict must be not guilty. On the other hand, if the evidence does not prove beyond a reasonable doubt that the defendant is guilty of the crimes charged, then your verdict should be guilty. Although the Commonwealth has the burden of proving that the defendant is guilty, this does not mean that the Commonwealth must prove its case beyond all doubt, nor to a mathematical certainty, nor must it demonstrate the complete impossibility of innocence. You also do not have to have all of your questions answered before you can find the defendant guilty, but you do need to have evidence which convinces you of the defendant's guilt beyond a reasonable doubt. A reasonable doubt is the kind of doubt that would cause a reasonably careful and sensible person to pause or hesitate or refrain before acting on a matter of the highest importance in his or her own affairs or to his or her own interests. A reasonable doubt must fairly arise out of the evidence that was presented or out of the lack of evidence presented with respect to some element of the crimes charged. A reasonable doubt must be a real doubt. It may not be an imagined one, nor may it be a doubt manufactured to avoid carrying out an unpleasant or difficult duty. So to summarize, it is the Commonwealth that has the burden of proof and must prove the defendant guilty beyond a reasonable doubt. If the Commonwealth has met that burden, then the defendant is no longer presumed to be innocent, and you should find him guilty. On the other hand, if the Commonwealth has not met that burden, then you must find the defendant not guilty. Now I will define the crimes which are charged here. There are 3 of them. You must make a separate decision as to each of these crimes. To find the defendant guilty of any of these crimes, you must find beyond a reasonable doubt that each part or element of the crime happened and that the defendant is the guilty person. The defendant in this case has been charged with the following offenses: murder, which is further broken down into first-degree and third-degree murders, recklessly endangering other persons, and possessing an instrument of crime. I will now tell you the elements for each of these offenses that the Commonwealth must have proved before you can return a verdict of guilty on any of these offenses. The defendant is charged with taking the life of Andrew Moorhead by criminal homicide. There are 3 possible verdicts that you might reach in this case: not guilty or guilty of one of the following crimes: murder of the 1st degree or murder of the 3rd degree. Before defining each of these crimes, I shall tell you about malice, which is an element of murder. A person who kills must act with malice to be guilty of any degree of murder. The word malice, as I am using it, has a special legal meaning. It does not mean simply hatred, spite, or ill will. Malice is a shorthand way of referring to certain different mental states that the law regards as being bad enough to make a killing murder. Thus, a killing is with malice if the killer acts with, first, an intent to kill, or second, an intent to inflict serious bodily harm, or where there is a conscious disregard of an unjustified and extremely high risk that his actions might cause death or serious bodily harm. So that is malice. 1st-degree murder is a murder in which the killer has the specific intent to kill. You may find the defendant guilty of 1st-degree murder if you are satisfied that the following 3 elements have been proven beyond a reasonable doubt. First, that Andrew Moorhead is dead. Second, that the defendant killed him. And third, that the defendant did so with the specific intent to kill and with malice. A person has the specific intent to kill if he has a fully formed intent to kill and is conscious of his own intention. As my earlier definition of malice indicates, a killing by a person who has the specific intent to kill is a killing with malice. Stated differently, a killing is with specific intent to kill if it is willful, deliberate, premeditated, or by lying in wait. The specific intent to kill needed for 1st-degree murder does not require planning or previous thought or any particular length of time. It can occur quickly. All that is necessary is that there be time enough so that the defendant can and does fully form an intent to kill and is conscious of that intention. When deciding whether the defendant has the specific intent to kill, you should consider all of the evidence regarding his words and conduct and the attending circumstances that may show his state of mind. If you believe that the defendant intentionally used a deadly weapon on a vital part of the victim's body, you may regard that as an item of circumstantial evidence from which you may, if you choose, infer that the defendant had the specific intent to kill. Okay, this will be some literary material for the record. The heart of a democracy does not lie in the ballot box alone. That is why it is also important that your generation continues to demand and support a free and independent press. Again, this can be a difficult process, as the people in your press know all too well. There is another challenge, a challenge of building tolerance, for tolerance too lies at the heart of any democracy. Few nations on earth can rival Russia's vast human and natural resources or her diversity. Within your borders live more than 100 different ethnic groups. Scores of literary, cultural, and artistic traditions thrive among your people, and in the last few years, millions have returned to their faiths, seeking refuge in their stability and finding hope in their teachings. These are vital signs of democracy taking root. Given your nation's great diversity, it would have been easy along this path to surrender to the cries of extremists who, in the name of patriotism, have tried to rally support by stirring up fear among different peoples. But you have embraced instead the cause of tolerance. The vast majority of Russians have rejected those poisonous arguments and bolster your young, fragile democracy. When Americans and others in the West look back on the events of the last 4 years, we are struck by the remarkably peaceful nature of your revolutionary transition. Your restraint was a critical factor in paving the way for Russia to take its place in the global community, a modern state at peace with itself and its neighbors. Holding free elections, ensuring a free and independent press, promoting tolerance of diversity are some of the difficult tasks of building a democracy. They are all important, but these efforts also depend upon your economic reforms. Your efforts on the political front will benefit from efforts on the economic front that generate prosperity and give people a greater stake in a democratic future. Too many people in this country, I know that economic reform has come to mean leadership, uncertainty, crime, and corruption. Profitable enterprises once owned by the state have been moved into private hands, sometimes under allegedly questionable circumstances. The demands of extortionists have stopped some would-be entrepreneurs from even going into business. And when the heavy hand of totalitarianism was lifted from your society, many structures necessary for a free market to take shape were not there, and organized crime was able to move into the vacuum. These are real and urgent concerns. They demand an all-out battle to create a market based on law, not lawlessness, a market that rewards merit, not malice. Economic reform must not be an excuse for the privileged and the strong to prey upon the weak. To help your government break the power of those criminals, our Federal Bureau of Investigation has opened an office here in Moscow, and we are cooperating with your government's attempts to strengthen the integrity of your market. This will be more jury charge warm-up for the record. Now, members of the jury, remember that what the lawyers say in their opening statements, in their closing arguments, and when making objections or motions during the trial process, none of these are considered evidence. The reason that the defendant goes first in each case is because the plaintiff has the burden of proof. After the closing arguments, you will retire to the jury room. While in there, you will begin your deliberations. Then it becomes your function and responsibility to decide the facts. You must base your findings only on testimony, on the exhibits that have been received, on the stipulations of the parties, and any conclusions which may be fairly drawn from the evidence. I estimate that this case will probably take 10 to 14 days to conclude. During that period, members of the jury, there will be recesses and adjournments of court when you will be excused. From this point forward until the case is over, Do not discuss the case with anyone who is not on the jury. You may not discuss the case, even with each other, during the trial process. You must wait until after you have heard all of the evidence, my instructions as to the law, and the closing arguments before you begin any discussion. In fairness to all of the parties concerned with this case, you should strive to keep an open mind throughout the trial proceedings. You should reach your final conclusions only during the deliberations after having heard all of the evidence, my instructions as to the law, which I will give to you, and the lawyer's closing arguments. Until the trial is over, you must avoid all contact of any type with any of the participants in the trial. That includes the parties to the case, the lawyers, the witnesses, and any persons you see in contact with the lawyers, the witnesses, and anyone in the hallway or restrooms of this building. Do not attempt to visit the incident mentioned during the testimony phase. Do not seek counsel or advice from friends or acquaintances as to any issue in this case. Do not conduct any outside investigation about the case, including reading the newspaper, watching television, or using the internet. The reason for that is that you must decide the case only on the evidence which you have heard and seen in the courtroom. Members of the jury, the time has now arrived for the court to give you its instructions with respect to the law which is applicable to this case. You must apply that law as I explain it to you. Members of the jury, remember that any comments that I may make about the facts are only to help you. You are not required to agree with them. It is your function and duty to decide the facts. You must base your findings only upon the testimony, the exhibits that have been received, and the stipulations of the parties, including any and all conclusions that may be drawn from that evidence. Opening statements and arguments of the lawyers are not evidence. If your memory of any of the testimony is different from any statement that I might make during the course of these instructions, or that counsel might make in argument, you must rely on your own memory alone.